I'm Doug Lichtman, and this is the first video in our series on patent law. I always tell the law students that patent law is one of the most important areas of law, and I actually believe that. Patent law, it moves an incredible amount of money around. And yeah, I'm not one to tell you that money is the end-all be-all. That's so not me. But moving money around is a great way to change behavior. If we can move big sums of money around, we can get research done, we can get products developed. Moving money around is a powerful way to change what people are doing day to day, what they can do because they have the resources, what they actually do because of the incentives related to money. Moving money around is an enormously important way that law changes our lives. And I always tell folks, like tax and patent law, they're actually really important areas no matter what you care about because they move tremendous money around. And like I say, I really believe that. Imagine you're someone who cares a lot about the environment. While you certainly should care about environmental law, the specific rules that govern what you can and can't do to the environment, you also have got to care about tax law, because through tax, through subsidies, through various tax programs that alter the tax consequence of various behaviors, that's how we get you to behave when we're trying to change what you do as a company to the environment. You care about patent law, because the incentives patent law creates, that might be the thing that gets us the new electrical vehicle engine, the new battery technology, whatever it is. All these areas, you think, gosh, I wish I were a doctor but can't stand the sight of blood. Well, okay, in the law, one of the areas that really matters and really relates to medicine, it's patent law, it turns out. Right? We do so much in patent law to encourage the funding of research that leads to new medicines, new technologies. Patent law and tax law, they move tremendous money around and they touch everything. Whatever you care about, these two areas of the law help shape behavior. And so I think patent law is tremendously important, and I'm excited to walk you through a bunch of videos about how patent law works. I'll say at the outset, patent law is pretty disappointing. Which is to say, well, I can pitch to you this amazing thing it does, moving the money around, inspiring people to make these new technologies, to deal with medicine, to deal with the environment, all these wonderful things. I could tell you that story and it's true. The reality of patent law on the ground is we fall short all the time. A lot of things that are patented, they're actually not that impressive. A lot of the cases that move big dollars around, you look at it closely and you think to yourself, we're moving money to the wrong person or the wrong entity, or we're taking money away from someone who's actually doing something awesome in the world. They were running a cool business, they were making jobs, they were moving us forward. We're taking money away from those folks sometimes. I'll show you as we get going there are a lot of points where patent law disappoints. However, this area of law could be amazing, sometimes is amazing, leads to breakthroughs that change our lives in a wonderfully beneficial, positive way. And we'll walk through all of that in the videos ahead. Where then do I want to begin? I want to start with the documents, and I'm not going to start with the real first document, because as you might know, to get a patent, I apply for a patent. And so technically the first document in the chain is an application where I say, hey, here's what I invented, government. I would like you to evaluate it with me, and if you agree that I invented something that qualifies, I'd like a patent. I'd like these legal rights that give me ball control, right? That stop other people from using my invention for roughly 20 years. If we were really being disciplined, we'd start with applications, but I don't want to do that. Instead, what I want to do is I want to start with a bunch of issued patents and show you what's in a patent. Obviously, the stuff that's in a patent comes from the applications, but the patent is a cleaner way to show you what this area of law is about. So I'm not going to start with an application. I'm going to start with a series of real patents and kind of walk you through the documents, what's there and why. And then again, in later videos, so much more to show you. Let's get started. Here's a first patent. This is my favorite teaching patent because it's kind of straightforward and simple, but the flow of the document is the same flow you'll see in much more complicated technologies. This is a patent, you can probably tell from the graphic, for a dog bowl. And let me blow up the first page there. So let's just move through the document a little bit. In the upper left, it says it's a United States patent, and it has this name, Weisenhagen. This is the person who is the inventor, and the US system really focuses on people, right? We will make you disclose when you apply who are the people who actually work to create this invention. And that's a little bit romantic, like to focus on the people. It's also a little practical. If I ever want to litigate this thing, or maybe even license it, this guy, Weisenhagen, he's something I probably should talk to, find out about, reach out, and so on. It's a little bit romantic, it's a little bit practical, but the US system really focuses on the people, even though you and I know a lot of inventions happen in the context of companies where it's a team that the company put together, pays for, guides. A lot of the work is actually not so much just the people, but an entity. And we do acknowledge that to some degree. A patent, when it issues, will sometimes immediately be assigned to the business, not the people. But in the upper left, United States patent, and the name in this case of the one guy who said, hey, I invented this dog bowl, it's mine. That's Weisenhagen. In the upper right of the document, you get the patent number. This is an old one, and even there you could see we're up to 5,900,000, right? Huge numbers. We're even further along today. Usually a patent lawyer will use the number by referring only to those last 3 digits. So I might call this the 016 patent. I'll refer to the last 3 digits, because in context, you probably know which one I'm talking about. I don't need to get out this whole long number. And you'll see this in legal documents and court cases. It's the 016. Below that is the date it was issued. Patents are enforced when they're issued, with a couple tiny exceptions, not when they're applied for. And so that date's really important. As of November 2nd, 1999, that was when this thing is in force. And so if it's a good patent, it means as of that date, you can't make this dog bowl unless you have a deal with our inventor, Weisenhagen. I'm back on the left side. Patents usually have a title. You're not bound by this. We don't read much into this. As someone who applies for patents, you want to do a good job choosing your title, because this is how the patent office, the government entity that receives and evaluates patent applications, this is how the patent office figures out, oh, this one should be assigned to Joe. Joe is our expert on dog bowls. He'll be the right person to figure out whether or not to issue the patent. And so the title helps the patent office get it to the right team. And as you can imagine, the patent office is huge. 5,000 to 6,000 equivalent full-time employees working in their areas of expertise. If you turn in something about jet propulsion, great. We try to get you to someone who knows already something about that area. So the title is part of how we route the application and part of how we later keep track of what the heck this thing is. But it's not binding. That's the title. Below that, again, we have the name. The inventor might point to you that we really focus on that. Even if his address, maybe we'll drop in someday and say, hi, I always wanted to meet this guy because I always teach his patent. Below that, we have the application number. So you can go back and say, hey, I want to look at the file that led to this patent. Because again, in the US system, you apply for a patent. There's then a period of back and forth with the government where you say, I'd like it. The government says, I'm not so sure. I don't think it's innovative enough. I don't think you disclosed your invention properly. Whatever they want to say back, there's a back and forth. And all those documents are public. Indeed, today, you can just log on to the internet and go grab them immediately. Back when I started teaching, you'd have to wait like a month and ask the government to send you a box of the documents, or you'd have to go in and like stand there and photocopy them at the patent office. Now you can get all this stuff. The application number is one way to look it all up. I see the patent, I say, I'd like to see what it looked like when they asked, and then I'd like to track the back and forth documents as the applicant argued with the government to try to get the patent they wanted. Vocabulary-wise, by the way, that's called patent prosecution. And patent prosecution is just that back and forth process where I ask, the government says no, I say please, the government says no. It's that back and forth. It's called patent prosecution. All right, we have the application number. We have a filing date. That could be really important also. We'll talk about it in a later video, but we judge your proposed invention, at least in part, as of the date you filed. When I say I invented something new, one thing the patent office does is say, well, was it new? And the question is, was it new, largely, as of the date you filed? After you filed, right, there's government stuff going on, we might delay the back and forth. What we want to know is, when you knocked on the government's door and said, I've actually invented something, we want to judge you in light of what was known as of that date, mainly. So the filing date becomes really important. The filing date is also important in the modern system because roughly you get 20 years of protection from your filing date. So that date becomes really important even if you dance with the patent office for 2 years, which is pretty conventional. Around 2 years is a normal pattern. Sometimes it'll be longer. But if you dance with the patent office for 2 years, we don't want you to then delay your 20-year term. And so we say, we're going to keep an eye on the filing date with a couple exceptions. We're going to keep an eye on the filing date and give you roughly 20 years from that date. So really important information about how long the patent lasts and how we're going to judge it, all buried in that filing date. Below this, you get these international and US classifications, field of search. What's that? Think of it like the Dewey Decimal System, but for patent law. One thing we're going to do when you knock on the door and ask for a patent is we're going to compare it to stuff we know. And to do that, we kind of got to box it in. What is this? Oh, we should compare it with other food bowls. We should compare it with other things that are related to caring for a dog. There are going to be categories. We're going to try to put this thing in, both to organize the patent when it issues and to help us figure out what should we look at to determine whether it was new, whether it was innovative. You're going to show me your application. I'm going to look at other dog bowls, which are hopefully in these same categories, and now say, all right, what's new about yours? Does it qualify? We get a hint of that in the document. Below that, we get a list of US patent documents. It actually also follows on the next column as well. This is the examiner, so the person at the patent office who read this thing, went back and forth with you. The examiner is going to note in the face of the patent, here are some things I thought were pretty darn close. This is important prior art. Prior art is just our fancy word for what did we know. And this is some evidence about what we knew. Here are some old patents that we can look at to get a baseline. You say it's new, as of your filing date, awesome. Here's some evidence of what we already knew so we could do some comparisons. And they listed a handful of patents. There's a foreign document listed here as well. Below that, we get the name of the examiner, the government official who did the work on the government side, and the name of the attorney who fought for our inventor. Now we have the abstract. Again, this isn't really binding on anybody, but when you file, you give them a title, you give them an abstract, like a quick summary of what's cool about your invention. Again, to help the patent office assign it to the right team to do their work. This is also helpful, it's not binding, but helpful when you and I go to read a patent. I'm going to start with the title and the abstract and hope that orients me to what the patent's about, even knowing it's not binding on the writer. Also on this front page, I'm highlighting the little one instead of the big one. There's a, hi Fido, that's the drawing. There are drawings indeed on the next page of this patent. There's the next page, there we go. There's a bunch of drawings, right, to help us visualize the invention. This is a dog bowl. I didn't read you the abstract. I'll represent to you. What's potentially cool about this is it doesn't slide around when the dog is eating from the bowl. You could see those little wings on the side kind of stabilizing it a little bit. It's designed to make it so the dog can eat it, can be very excited to eat, but the bowl doesn't slide. You might also notice in some of the cross sections like figure 4, or maybe the one that's a little cut off at the bottom with the numbers 26 and 15 on it, the top of the bowl kind of has a curved lip. And the patent talks about how when the dog is eating and the food's getting pushed out the bowl, this way it comes back around and falls back into the bowl. And a bunch of drawings. I always joke with my law students, like if you got to law school and realize you don't want to be a lawyer, this is a cool law adjacent job. Maybe this one feels a little silly, right? They drew a dog, okay. But when you're really coming up with something like mind-blowingly cool, it actually takes a lot of skill to draw it, right? How do I capture in a visual this amazing achievement in a way that doesn't accidentally limit it, in a way that really captures its richness and its properties, Every patent has drawings. That's a big part of a patent application. You could see with all those little numbers, right? We're going to use these drawings to explain the idea later in the document. In the document, you're going to see there are sentences like, as you can see from items 15 and 12, and away they go. And so this is a really integral part of capturing innovations, but it maybe, scratches a different itch. If you don't love being a lawyer and writing prose and the stuff that lawyers do, maybe this is a cool kind of law adjacent kind of job where you're doing something interesting and worthwhile and wonderful, but getting to use more of a graphic arts skill set to communicate information. So here again, don't oversell this. It's a dog bowl. They drew it. This is one of the later pages of the same patent, and yes, my graphics are getting more playful. I've had more time to play with my slides, so I'm experimenting. One thing I want to point out to you here is you get the summary of the invention, pretty standard, almost every patent. The inventor pitches you on, hey, here's my big idea. And often they'll tell you about what came before and pitch the idea so that you can see in their view why it's interesting. Right? This is advocacy to some degree. This is the first thing the government bureaucrat's going to read as they figure out whether to say yes or no or push back in some way. And so I tell the story, it's been a problem forever when you fed your dog that the dog would get so excited for the kibble that they'd slide the bowl around. It makes a terrible noise, kind of squeaking on the floor, and the food falls out. I've got a solution. You can imagine selling it before you dig into the details. There's some details here. I'm not going to dig in very far on this one, other than to show you the end. So I've got the beginning, the data, the drawings, the summary. There's some prose in there explaining the invention. And then at the end, every patent ends with claims. And this is super important. This is a set of numbered sentences where the lawyer tries to say, based on what I just taught you, this is what I own. This is my fence. I want a document that says this is mine. If you see this dog bowl in the wild, it's mine. They need a license from me or they have to stop doing it. These are the sentences where, having done all of the explanation, drawings, prose, I've done all the explanation, now I come back and say, all right, given all that, using the words I've taught you, because I've taught you about the lip and how it's curved and whatever, using what I've shown you, here's a precise legal sentence of what I think I own. And indeed, several sentences. A good patent might have 15, 20, 30 claims, formal sentences to say, I think this is what I invented. Here's how you can identify it. If you see these elements, that's my dog bowl. And again, they do it here. I'm not going to loiter here. This claim is actually not very good, but I like this patent because it's short and accessible, just to show you the pieces parts. Here's another patent, getting slightly more complicated. This one actually is part of a patent family that's worth a fortune. The inventor in these patents ended up licensing the stuff to Starbucks. The invention, and there's a couple patents related to this invention, the invention is those little sleeves that when you get a hot coffee at Starbucks, right, they used to put 2 cups, right? They'd give you the cup of coffee, give you a second cup and stack them in order to protect you from touching too hot a cup surface. And then they gradually moved to these sleeves that they store on the counter, they pump them open, they slide your cup in, and it's a lot less material. They just give you that little section you need to hold the cup, but don't actually waste a full cup. And indeed, as these patents teach, this is a big deal, right? Because those sleeves, first of all, can be stored flat. You might perceive our barista picks it up, pops it, and makes it 3-dimensional. But until then, it's stored flat, which is great for Starbucks, right? The alternative being like a cup, which takes up a lot of space and could be damaged in transit. This is designed to be flat. It uses very little material. These things were engineered to have these little air pockets to really cushion you from the heat effectively. They also gave you a place to put a note. The barista can write your name on it. They can put an advertisement on it. There are all these charms, and as the patents lay out, this one and some others, they say, hey, that's our move, right? The prior art was this awful, wasteful, hard to store alternative. Look at us. We got this little sleeve thing. Stores flat, pops open, you can write in it, still does the job. These patents ended up being worth a fortune. Here's the first page again. Again, you know the elements. right? We've got a patent number. This is whatever, the 497. We get an issue date. It looks like it's 1995. The title is Cup Holder. It's not dramatic, but it is a title. Jay Swartzen's the inventor. We get all the stuff I mentioned to you last time, these classifications that it fits into, some prior art disclosures of other things that came before. You get the abstract, which I've highlighted for you. What is this thing? It's a cup holder and explains the ideas I just reflected to you. Same setup, slightly more interesting setting, same setup as last time. Again, drawings. Here, they're a little more helpful, I think, helping you to see like figure 3 showing the corrugated layers, figure 1 showing how the holder goes around the cup. This one had like these little wings, that is how they attached it together. The modern one doesn't even have that. The modern one just pops open. But showing you the pieces, again, those little numbers just tell us that there are going to be sentences in the document that refer back. Teaching you, hey, so you can understand how it works, let's look at 30. 30 is this uneven edge. Here's why it's uneven. Here's how it works. The drawings get integrated into the disclosure. I'm inside the patent now, one of the deeper pages. Again, I just want to show you that you kind of know how to read patents already. There's this background sentence. It's advocacy, right? This section is the lawyer trying to convince you that this thing is awesome. It might not be comprehensive. It might be that if you and I know this area, we'd say, well, that's not quite right. Fine. This is their attempt to pitch it. Read it with that in mind. You still might learn a bunch. Background art, this section, they're kind of laying out, here's what the world looked like before us. They'll then obviously say a bunch of things as we keep going. And ultimately, after they teach the invention, again, it ends with claims. Having taught you all this, this is what I think I own. And again, I'm not going to load around these claims either. I also don't like these claims. Indeed, it's really funny. They almost messed up all the money they were going to get from Starbucks. In their claim, when they wrote this one, they wrote a cup and holder combination comprising a cup for holding hot liquid and a holder defined by, and they explain then, hey, here's the holder. The silly thing they did is you shouldn't list the cup, right? Their invention is the holder. What they wanted to own is the holder, the outside piece. They didn't invent the cup. And it's important because if you think about how this patent would get licensed and used and so on, their problem will ultimately be that someone else will start making the little sleeve. And they'll want to sue that person and say, don't make that sleeve, that's my sleeve, you can't do that. And those third parties, they're not making cups. They're just making sleeves. Starbucks marries the sleeve to the cup. But the patent should focus on the invention because that's what I want to go out and enforce. The thing should have just talked about the sleeve. And yeah, sure, the sleeve is understood intellectually as having a relationship with the cup, but the sleeve is the actual invention. So I don't love this claim either, and they did come back into a fixer patent and got rid of the cup. But for now, just showing you the flow. Let me show you one more. This is a heftier patent. This is a patent on a pharmaceutical that is used for folks who have narcolepsy. If you have trouble sleeping through the night, this is a pharmaceutical that helps you get a good night's sleep. I'm not going to go into it right now. It does show up in one of our later videos, a bunch of interesting things related to this patent. For now, all I'm going to show you is when we get to the more economically valuable patents, the ones where the person writing it knows, my goodness, this is going to be a billion-dollar drug, you just see the same elements we saw for the dog bowl and the same elements we saw for the comparatively simpler sleeve. Same elements, but just like really emphasized and grown and built up. What do I mean? Well, there's that patent number. What do I mean? These pages are the list of prior art documents that were shown to the examiner. Remember, in the dog bowl it was like 5 items, and in the Starbucks patent it was a couple items. Look at all this stuff, column after column after column. And did the government really look at all this? Probably not. We think on average examiners spend about 18 hours on the entire process. That's from, hello, nice to meet you, reading all the documents, writing back and forth. There's no way an examiner is going to read this much stuff. That's a problem in the system, by the way, because on the face of the document, it kind of looks like the government looked at all this and judged and said, hey, despite knowing all this, wow, this new thing is an achievement. And gosh, I don't think that's true. But as someone who writes patents, man, you want to list a bunch of stuff there because you want to be able to make that argument. If you're later using the patent in a negotiation or fighting for the patent in court, you want to say the examiner was really well informed. Look at all that stuff. And they still issued the patent. And so you see in these patents that folks know are going to be of high economic value, you see this dump of information. Again, it's the old stuff, but wow, kind of on steroids, if you will. So too inside the document. Again, I'm not going to read it with you, but these are just 3 of like the 30 pages of this document. And what you see is lots of data tables and disclosures showing, in this case it's a pharmaceutical, what's in there, how does it work, what do we know, about how long it lasts in the bloodstream, all that kind of good stuff. All right, last thing I want to do in this introductory video, having shown you a bunch of real patents, I really want to slow down for a second on claims. Claims are so important. It's what you get. Everything else that we do, the disclosure, the drawings, the paragraphs, it's all designed to support the claims. And that's what I want, right? At the end of the day, when you hand me a patent, I get 20 years to stop other people from doing the claimed things, right? That's what I get. And so the claims are really important to understand the scope of a patent, the value of a patent, the weaknesses of a patent, you name it. Claims are really important. And intellectually, legally, strategically, all the other stuff is designed to show that you're entitled to the claims. I teach you the invention, I disclose my data, I compare it to the prior art to show you that now I get this, right? Based on all that, this is what I get. So claims are really important, and I wanted to show you how to read them. So as we deal with cases, and you're not going to do a lot of this, but I want you to be aware of this part of the patent system, given how central claims are to everything we do. What do I want to show you? Well, let's start in my example 1, claim 1, up there at the top. And the first little couple words we call the preamble. And a preamble is just kind of the opening hook, just to start my sentence. And for the most part, the words don't matter at all. I could literally say a thing, an apparatus, a chemical, a machine. I don't have to be precise. I don't have to use adjectives. I could be really lame to start my sentence. Most of us give a little something just to help the reader read the sentence. And so here, for example, I did a diagnostic medical imaging system. It gives you a sense of what it is I'm claiming. And again, as long as I'm light in my touch here, nothing turns on this. No court holds me to these words so long as I don't put in too many details. I can mess that up, by the way. If I write a preamble and start saying a lot, a diagnostic medical imaging system that is used in kidneys on Tuesdays, if I start saying too much, yeah, I'm going to be held accountable for those words. But in general, our view is it's filler to help make these things readable to the patent examiner, to potential licensing partner, if need be to a judge and a jury. Preamble, just the opening hook of the sentence. After that, we have what we call a transition phrase. And the only one I'm going to focus on is the one that almost every patent uses. It's the word comprising. And the word comprising, we've litigated it enough to know what it means. And what it means is, I'm about to highlight for you the essential elements of my invention. You'll know it's a mousetrap because of these things. You're going to see cheese, you're going to see a spring-loaded door, and you're going to see a portable container to hold the mouse. Comprising says, I'm about to list for you the key elements. And indeed, it says, these are the key elements. So if you see something that doesn't have one of them, it's not a mousetrap. If you see something that has more, that's fine, right? You might add a pretty bow, a bell, a whistle, that's fine. But comprising means I'm going to highlight for you those handful of elements that will help you identify my invention in the wild. Comprising. If it's helpful, think of my sentence as saying like comprising elements A, B, C, and D. And what I mean is to say, if you have something that has A, B, C, and D, it infringes, it's mine. If you have something that has A, B, and D, you didn't include C, well, that's not my thing, right? I said comprising A, B, C, D, you gotta have all of them. But if you give me A, B, C, D, E, you added something, it's still mine. It's still a mousetrap. It has A, B, C, D. Comprising is the transition phrase that means all of that. I'm going to list the elements in a second. Those are the things to look for. If you're missing any of them, it's not my invention. If you add stuff, yeah, it's still my invention. Comprising. Then we actually list the elements. And as you'll see, I'll read it with you in a second. When I list the elements, I not only identify these things that are so important, I also tell you how they connect to one another. It's not like throw the elements in a bag and shake. That's not my invention. They have a connection to each other. And so what you'll see is we list out the elements and we refer to other elements so you understand how it all fits together. And so here I have this diagnostic medical imaging system comprising element number 1, an ultrasound image generator, and element number 2, a flat panel display capable of displaying an ultrasound image generated by said generator. Okay, I've typed them together. Here's the generator, here's the flat panel, and you know how they relate to each other. And again, what this means is if you show me something that's both of these things, that's my patented invention. You can add stuff, but if you take something away, it ain't mine anymore. Let me jump ahead to another example to give you the same flow. Here again, I have a patent that begins with a preamble. This time it's a method of forming a porous surface for use with an orthopedic implant. That preamble is longer. It might be a court's going to say, I'm going to actually hold you to those words because you gave me so many details. You didn't just say a method or a method of making stuff, right? You gave me the orthopedic implant. So, okay, maybe we'll hold you to that. That's my preamble. I then have this transition, said method comprising the steps of. Again, comprising means I'm going to give you my steps. If you don't do these things, it's not my invention. If you do these things plus more, that's still my method. Preamble, comprising, and then we list out the steps. The elements this time are providing a plurality of metallic particles and mixing a water-soluble protein compound with those particles. 2 steps connected together. So the basic reading of a claim is that preamble, the word comprising for our purposes, and then the list of elements. The only other thing I want to show you about claims, remember I pointed out to you that at the end of a patent, you probably have a bunch of claims. Sometimes that's the lawyer saying the invention in different ways, maybe at different levels of abstraction, for instance. My first claim might be to a mousetrap, and I talk about it having something that attracts animals. Right? I don't say cheese. My element is an attraction component. And then I keep going, right? And instead of saying like a spring-loaded door, I say a closing entry position, right? I might try to say it like some sort of big sweeping way, and then I'm going to try different levels of abstraction. Maybe I'll come back later and say, forget this fancy language, it's cheese, and the door is spring-loaded. That's how it closes. I might just talk about my invention at different levels of abstraction in order to sweep more and less broadly. I also might focus on different aspects of my invention. Maybe in one claim, I'm going to really emphasize that I'm luring the animal in. That was the cool part of a mousetrap, by the way. Originally, if there's a mouse in the house, right, you chase the mouse with a broom, and if you got him, you did it. What are you going to do now? The cool thing of mousetrap is we attracted the mouse to the trap. Maybe I just focus on that, something that lures the animal in. Or maybe I write a claim that focuses on the fact that it seals and is portable. Another huge piece of this achievement, again, when you're chasing the mouse in your house, if you got it, now what? Whereas this way we seal them in, you could take them to your neighbor's house and let them go there. Right? Depends what you want. So as you think about the claims, you might just be kind of thinking about different ways to talk about the achievement in front of you. Some of how you might do that, though, is through this idea of dependent claims. And that's what I'm going to show you in the slide. There we go. Claim 2 is dependent. It refers back to Claim 1 and adds narrowing details. Claim 1 is the one I read out loud. It's a method of forming the porous surface, has those 2 steps, a providing and a mixing step. Claim 2 says, hey, the method of Claim 1, where that protein compound I mentioned, it's gelatin. And note, this is narrower. Claim 1, the protein compound could have been anything. If it was gelatin, that counted. If it was any other protein, that counted too. Claim 2 then is narrower. I've kind of taken a step back. This time I'm going to clarify a smaller position. That was true in my mousetrap example for you also. If my broad claim talked about a lure, something to attract the animal, and my dependent claim follows up and says, that idea I just told you, where the lure is cheese, I've narrowed. And what we see in patents is lawyers write dependent claims to stake out fallback positions, narrower positions. I'd love to get claim 1 issued by the government, take it out into the world, and it's awesome, right? It wins in court, everyone respects it, awesome. But in the event I have a problem with claim 1, let's say it turns out I claim too much, and my claim is so broad it covers something that I didn't invent, or it covers something that someone else already knew. If my claim is too broad, I'm grateful to have a fallback that I wrote on day 1, right in the original patent. They say, look, if claim 1 doesn't work out, how about claim 2? And claim 2 is this narrower statement. Look at my claim 3, the method of claim 2, where I'm further narrowing it such that the metallic particles are titanium. Again, claim 1 had any metallic particle. Now I'm backing off and giving you a specific. And lawyers, you can think about a lot of ways to narrow in different groupings and along different dimensions. What I want to point out to you is this structure. We have what we call independent claims. They stand alone, like claim 1. Look at the camera, say what you're gonna say. These are my elements. Then right from the first moment, kind of cool, the patent system recognizes we might mess up. It might turn out that claim 1 isn't good for some reason, fine. We write these insurance policies where I claim a little less. I claim a little more specifically. And that helps me if my broad claim fails. And there are lots of ways it can fail. Again, I might have patented something in the broad claim that I didn't actually invent. I might have claimed something that someone else invented. All sorts of ways I could mess up. And right away, the system is super self-aware about how hard it is to write claims. If you invented something amazing, to write it in words is tough sometimes. Think of the first time you met the internet. Could you have written a sentence to explain what it turned out to be? Probably not. It's a really hard project, and so right away the law is self-aware and says, look, write the broad claims, we'll kick the tires, the patent office will ultimately say, yeah, fine, you can issue that. And then write these insurance policies, these fallback positions. In case something goes wrong with the more sweeping ones, you have other ways. Some of them will be independent claims, pointing out the invention using different words or different points of emphasis. Some of them will be dependent claims, narrowing like my examples to you. And this way we have this backup stuff. And you know what? It might be useful in other ways too. Even if I don't lose a broad claim, it might be if I go to talk to you about my mousetrap or litigate my mousetrap, it might be nice to just be able to say, you know what? It's got cheese. Look at claim 9. Don't read my highfalutin sweeping lure and so on. Don't worry about that. Read claim 9, where I got right down to the detail and said, my device has cheese and a door with a spring. That might be great language to talk with you about licensing it. It's concrete and the thing you want to license. It might be great language if I'm in front of a judge and a jury. They don't have to think so hard about what does it mean to lure an animal. Cheese, got it, go. Dependent claims are insurance policies, and they also sometimes are just a more clear way of talking about the achievement. And so you'll see patents end with these webs, pyramids, lists of claims. Again, sometimes a couple independent, some dependent based in the independent, and there's strategy here thinking about, well, what's worth doing? If I have a lure as my first claim, will I follow up then with where the lure is, any of a sound, a smell, a color, to picture a bunch of categories? Might I follow up again where the thing is in fact a food product? Right? You can imagine writing and thinking about kind of what are my stopping points. If my biggest category is something that lures the animal, and my smallest category is cheese, thinking about kind of what are worth bothering with in between that'll give me meaningful additional protection. When the government evaluates a set of claims, they focus on the independent claims. Because if I think you're entitled to the broad one, of course you're entitled to the narrow ones too. And so in the process, remember I called it patent prosecution, in the back and forth with the government, the focus is on the independent claims, and we'll just check like punctuation for the dependent claims. But then when you take your patent out to try to do stuff with it, those dependent claims sometimes are really important to actually getting value from the patent. Just another claim there in my slide, another dependent claim. All right, that's our introduction. What I hope you picked up this time is you get to see a bunch of patents, maybe have a little flavor for what some of the issues are going to be, things like prior art, things like the date when you disclose things, the articulation and claims, and then obviously we'll build a ton more in the videos ahead.